The courtroom's barely open, and already felony charges are flying. This is your everyday docket. This is where careers, families, and freedom hang in the balance.
Who's up? Who's up? Anybody? Three cases are called 23 CR 110, first degree felony, aggravated assault, family violence.
Your Honor, there's two cases pending. That's where he's
I'm not through. 23 CR 120. We gotta work through these here. Third degree felony, an indictment, a third degree felony of unlawful possession of a firearm by a felon. And in that case, stand by. As the previous case, one or more prior felony convictions are alleged. So this aggravated assault in 110, it's enhanced to, correct me if I'm wrong, no less than 15.
That one, Your Honor, they're not in sequence, so it pushes it up to the
One level. It's a first degree felony in paragraph 1 with prior felony convictions. It would enhance.
Translation: those prior convictions just turned a bad situation into a potential life sentence. When you're a repeat offender, the law doesn't give you many second chances.
Enhance it to 15
yes,
to life.
yes, sir.
And then in 23 CR 120, it's a third degree felony with a prior conviction. So that gets enhanced if found guilty of all of that to a second degree felony punishment. And finally, 23 CR 340, aggravated assault, family violence. Again, all of these are on the same date. It looks like on or about February 8th. Yeah. 23. Is this re-indicted
Yes,
from
Your Honor.
110?
Yeah, that's correct.
So here, we can shred 110, right? We don't need that.
That's correct.
All right. So what did you do? Just add a prior conviction?
No,
On
Your
the
Honor,
first one?
as far as this, it had to be re-indicted because it said the previous one, it said caused physical injury, but in this case, it was just exhibiting the weapon and threatening.
So it was also changed to from a first degree to a
So
second.
second degree,
felony.
yes,
So
should be.
that's a
passed in
second
that.
degree felony then, but you have two prior convictions, which look like they're not in sequence, are they?
No, Your Honor.
So it's enhanced to a first degree felony. So you have a second degree felony punishment and a first degree felony punishment. Unlawful possession of a firearm by a felon and family assault. Okay, so and 110 here, that's gone. That's out of here. So that's not part of the game that we are playing in this case.
You need to make sure, Your Honor, that one is dismissed. It's still showing up as one.
Why? Yeah,
So we need to
that
make
needs to
sure-
be dismissed.
Make sure I think I got
Yeah.
That's part of our request, Your Honor, is to make sure they get that. So that's one less money has to pay.
What are his bonds now, please?
It's like 60 and 10, Your Honor, 60 on the aggravated assault, 10,000 on the felon.
Who set those bonds? Curiously enough, I'd like to know. Because they're woefully inadequate under the circumstances that I'm looking at with prior criminal history and the facts of this case.
That right there is the moment that changes everything. The judge's tone shifts because when a firearm and a pregnant victim are involved, even the smallest detail can swing the outcome.
Here, I'm reading the probable cause affidavit, which I'm sure would have been read, but let's see. Let's see. The victim says to the defendant, she was pregnant. The defendant then grabs her, pulls a gun, sticks it to her head, told her he would kill her and hit her in her stomach. It was a revolver.
Right over
Police show up. She has bruising on her right upper arm, redness to her shoulder, as well as left upper arm. Then it was located and arrested. A silver revolver with a wooden grip was located in the defendant's closet, bedroom underneath some clothes. It was a loaded Taurus 38 caliber revolver. So he was booked in for unlawful possession of a firearm by a felon because he has two prior felony convictions. And these facts also resulted in him being indicted for aggravated assault, family violence. Yeah. Anything else? What do you want to add from the state and then defense? I hear you.
I mean, Your Honor, again, like you said, I believe they were set way too low in this case. The state
What
would
do you
ask that on the assault with a deadly weapon, the state would ask for 150,000 and 50,000 on the felon in possession of a firearm.
I don't know, we would request a lower amount. We brought this to the attention. We've been in jail for almost a year now waiting.
I don't, so what's the point about that? Doesn't purge the facts.
No, it doesn't, but I was just, it's part of just the narrative to get to everything. It's just.
Okay, narrate.
Your Honor, we have requested set on trial. It was set for, I believe, last week. We were on a trial docket. We did not get reached for trial. This is something we intend to try and get resolved. But in the
I
meantime.
want to ask this. Defendant is not eligible for probation, correct?
Yes, correct, Your Honor. Yes.
There's a gun in his home, right? And it happens to match the firearm that was described by a complainant in another case. So let's talk about the circumstances of this case, if you want to or not. What do you say about the firearm?
Your Honor, it was found, it was not found on him. I would make the argument that it was not.
It was his home.
It was,
Who was he living with?
who was it?
I was in the home. It's not
But I mean, who lives there? It's not you. Other people live there.
it's not-
Who?
Or the victim.
The next day, they were there, so. But Your Honor, that's one of our arguments is that it wasn't found on this person. There was a whole issue about characteristic control.
Which doesn't need to be on this person, right?
No, but you still have,
Okay.
that's true. It doesn't have to be on the person, but you still have to prove the characteristic control, and there's gonna be some issues on that. Because it wasn't at his home by himself and there's some other arguments we're gonna make, but we'll make that a trial. It's not for here. But Your Honor, we just requested that we felt that this was too high, especially also we.
What about the assault of allegedly beating on a lady, which is about as ungentlemanly as it gets? The court has little tolerance for a man doing that, unless he's defending himself, of course. But I can't imagine the way I grew up, the way everybody should grow up, where ladies or should be treated like ladies. Those, I guess your story is she beat herself up to impress the police when they showed up. All right.
Your Honor, one of our issues was that currently, like I said, both cases are active. We want to make sure the older one gets suspended, so that takes one less bond off of the table for him to have to pay. Because as we've got here this morning, they're both still technically pending. So that was one of our arguments. And I think the court already ruled.
What about it?
Well, I think the one that's been re-indicted from needs to be dismissed because it's no longer active. But I think
Okay.
court-
Well,
yeah,
that,
yes, yes.
that doesn't make
Procedure, yes.
Yeah,
And Your Honor-
that is certainly correct.
Yes,
He
yes.
doesn't need, that shouldn't be against him. Two charges of the same event.
Right.
Costing him, no, that should be erased immediately, and it will be.
Okay.
We'll dismiss that. And Your Honor, it shows in the system that it's not showing a bond on that one in my system. It's showing it added an error to the side, and the actual bond is on the new
Okay,
indicted.
okay. Just make sure that Joe has that correct. That's what our issue is. They try.
It looks
But,
like they're trying, it's probably one of those problems of transitioning in this gigantic data system
Yes.
that we have suffered through in the last few months. But at least they put in something that he is not bond, he is not disqualified or required to set a bond on that case that was to be replaced, that's still floating around in the data system. So that should not be a prejudice to him.
But Your Honor, his family has attempted to bond him out due to the fact that there is the multiple cases to bond out, and the amounts he has been unable to do that. Your Honor, he is from here. He has family here. He has relatives here. Everybody's here. He has connections to the area. He's not a flight risk. There's no doubt about that. So then it comes down to the big question people always want to.
And this is where the moral weight of the case hits. The judge isn't just enforcing law. He's reinforcing values. Domestic violence isn't just a legal violation. It's a betrayal of trust at the deepest level.
The dangers of society. This is a violent crime. We understand, but this is a targeted crime, but this is not a random crime of violence. This is something coming out of a relationship.
Well, I mean, it goes against the whole idea that our American society is built around a family unit.
But
somebody beating up, allegedly beating up on the female portion of the family unit is going to be apt to ruin that relationship and cause hostility. This, I think our moral nature is one of peace in the home, which this defendant is charged with, completely and totally eradicating.
Your Honor, I think if the court would lower his bond, but add conditions in there of well, conditions are always in there, but no contact with the victim, obviously stress that. If the court wanted to add a ankle monitor or some other monitoring device to help prevent that or to monitor that. But we would request that it's come down to a lower amount in the range of 20,000. I believe 60,000 based on these facts is high.
They're $100,000 in each case. These are atrocious, but his criminal history especially, he has no room for error. But to allegedly be beating on the family, a family member, and also being charged with a firearm, which has gotten him in trouble in the past. He's a felon, and that is disqualifying him from his privilege and right. And I don't find that to be unusual, unreasonable under this fact situation and his criminal history. Also, if he does post a bond, he must have, he will be placed on home confinement, not the victim's home or the complainant's home, some other place that you are going to live. And you must have a GPS and can only leave home for certain necessities that the court would describe and spell out when and if you are bonded out. Let's set this for trial. Is that what we're doing?
It's already been on the product.
Let's try to get this as soon as possible.
sir.
And the defendant is ineligible for probation.
Yes, sir.
All right, so let's move forward on these things as soon as possible. All right, what's